Well, tonight, Donald Trump's lawyers have proved that they don't know why they asked for a special master to examine the documents seized by the FBI with a search warrant at Donald Trump's residence in Florida. We finally have tonight specific legal claims about some of those documents being made by the Trump lawyers in the appropriately titled case Donald J. Trump versus United States of America. Those claims appear in a Justice Department filing with the special master tonight. That Justice Department filing describes to the special master remaining disputes regarding 15 documents. The filing includes a table listing every one of those documents and every dispute. For example, document number 1 shows a dispute about the categorization of the document, with Donald Trump calling it a personal record and the Justice Department calling it a presidential record. There is also a dispute about the status of document number 1, with Donald Trump saying the document is subject to executive privilege and the Justice Department saying there is no such thing as executive privilege against the executive branch. And so it goes through the 15 documents. The most absurd disputes involve the disputes for document number 6 and others, where Donald Trump says the document is a personal record and the Justice Department says that it is a presidential record. And then Donald Trump also says that that personal record is subject to executive privilege, which the Justice Department obviously says is utterly absurd. The Trump lawyers do not make a single rational legal claim about the documents because there was nothing rational or legal about their request for a special master in the first place. The records that Donald Trump's lawyers call personal records, according to the Justice Department, quote, appear to have been created or received by plaintiff Trump in the course of activities which relate to or have an effect upon the carrying out of the constitutional, statutory, or other official or ceremonial duties of the president. The Justice Department points out that those documents include clemency requests and, quote, immigration initiatives, and, quote, a printed email message from a person at one of the military academies addressed to the president in his official capacity about the academy's sports program and its relationship to martial spirit. The Justice Department points out that there is nothing in law that suggests, quote, that otherwise presidential records may be rendered personal by fiat. The Justice Department also tells the special master, Raymond Dearie, Judge Raymond Dearie, what he already knows, which is that it is very common for personal records to be seized along with other material when search warrants are executed. Personal records that are not government property are seized every day for use in criminal investigations, and the fact that more than 100 documents bearing classification markings were commingled with unclassified and even personal records is important evidence in the government's investigation in this case. In the last line of their filing, the Justice Department says that all of Donald Trump's arguments about the documents, quote, would fail here because the government has a demonstrated specific need for this evidence in its ongoing criminal investigation. Donald Trump's lawyers have lost every round of the appeals in this case after the special master was brought into the case by the Trump-appointed judge, Aileen Mercedes Cannon. When you read the Justice Department filing to the special master tonight, you are reading a filing from lawyers who are confident and who are winning every single time they make an argument to a judge or to the special master. Donald Trump and his lawyers have to know by now, if they didn't know already, that they are going to lose at every turn procedurally with the special master in this case. And they are going to lose in the 11th Circuit Court of Appeals if Judge Cannon intervenes in the case again in such a way that the Justice Department has to appeal a decision by her in favor of Donald Trump's absurdist legal position. So procedurally, Donald Trump and his lawyers know that the special master process, while it might create some delay, is not going to stop the Justice Department's criminal investigation, which now appears to include the under oath testimony to a grand jury in Washington by the Trump staffer Kash Patel, who was chosen by Donald Trump to replace former White House counsel Pat Cipollone as Donald Trump's official intermediary with the National Archives about the documents that Donald Trump was keeping in Florida. Kash Patel was quoted in the FBI affidavit, which was used to obtain the search warrant of Donald Trump's residence, saying in May that Donald Trump had declassified documents that he kept at his residence in Florida. What did he say about that when he was asked about it in the grand jury in Washington last week? Kash Patel might have taken the Fifth Amendment and refused to answer any questions under oath to that grand jury, or Kash Patel may have decided it was time to save himself and stop lying for Donald Trump. Donald Trump's lawyers have no idea what he told the grand jury. Donald Trump and his lawyers have no idea what Kash Patel told that grand jury. Nothing prevents Kash Patel from telling them what he told the grand jury. But Donald Trump's problem is he is a pathological liar who has attracted into his employ other pathetic pathological liars like Kash Patel. So when one of his pathological liars is now telling him what he said to a grand jury, how can Donald Trump believe that? How can Donald Trump's lawyers rely on that? Such is the agonizing legal pressure that is building on Donald Trump every day, with every new revelation about a new Trump player testifying to a grand jury. We already knew that former White House counsel Pat Cipollone testified to the grand jury investigating the Donald Trump documents case, and we now have reports that Pat Cipollone has testified under oath in Georgia to the Fulton County grand jury that is investigating Donald Trump's possible criminal interference in the Georgia presidential election.
All I want to do is this. I just want to find 11,780 votes, which is one more than we have.
And today, Donald Trump's mascot, Lindsey Graham, lost his appeal in the 11th Circuit Court of Appeals, in which Lindsey Graham was attempting to avoid testifying to that very same grand jury in Fulton County, Georgia. The three-judge panel of the 11th Circuit Court of Appeals unanimously ordered Lindsey Graham to testify. Two of the three judges ordering Lindsey Graham to testify were appointed by Donald Trump, with Lindsey Graham's vote for their confirmation in the United States Senate.